Hello again, Michael, with the Iowa Firearms Coalition on Warrior Wednesday. We've got Richard Rogers with us. You may have seen him around from time to time up at the State House and shaking and moving and shaking. So, Richard, I spoke with you just the other day, and I wanted to know if you're willing to come on and talk with everybody about these court cases. I mean, they are happening as fast as I can possibly read them. And most of them sound pretty good, usually, which is very, very good for us. And welcome. So why don't you walk us through what's going on recently?
All right. Well, thank you, Michael. We haven't done this for a while. It's probably past time.
Yep.
Yes, there's been an awful lot going on in the courts. It's very helpful to the Second Amendment and to the work that we do up here at the Iowa Capitol. Iowa's got a pretty good situation because of what we've managed to accomplish over the last 15 years or so. But there are still things that need to be done, and particularly in the wake of the Bruin decision by the Supreme Court in June of 2022. To go back for a moment, let's just run down the important SCOTUS Supreme Court decisions over the years. There really haven't been that many until recently. Anyway, haven't been that many cases in the Supreme Court on the Second Amendment. There was the Miller case back in the late 30s that didn't go well, but then the plaintiff wasn't even represented by a lawyer. So what did you expect? And that thing has been misinterpreted a lot over the years, but there wasn't really anything else until 2008. We were getting pretty anxious, wondering if the Supreme Court was ever going to take up a Second Amendment case and set things right. In 2008, they had Heller versus Washington, D.C., and that established that this is an individual right, unconnected to service in the militia. So it put that to rest finally. People still try to resurrect it, but that won't ever go anywhere. And that arms that are in common use cannot be banned, because this was an issue about handguns in the home. And so the court could only deal with the issue, the case at issue, the facts at issue, and that was this was about handguns, which were banned in the city and in the home. So it established that you have a right to have a gun in your home, protected by the Second Amendment, and that handguns are commonly used for lawful purposes and therefore cannot be banned. So then in 2010, in the McDonald versus Chicago case, the court ruled that the Second Amendment applies to the states and the political subdivisions of the states, which was the first time that had been held. So that was very, very helpful, obviously. In 2016, there was what's called the Caetano case out of Massachusetts, where somebody had been charged with using a stun gun, which were banned in Massachusetts. And the court said that, nope, you can't do that. It's protected by the Second Amendment. Why? Because they're in common use. And there were, 200, they said they estimated that maybe 200,000 sold in the entire United States. Common use. Okay, we'll take that. But the big one is in 2022, two and a half years ago, the case of New York State Rifle and Pistol Association v. Bruin. Bruin was a police official in New York. And that established that the, I think, 109-year-old Sullivan law related to getting weapons permits to possess or purchase, as well as permits to carry in New York, was unconstitutional violation of the Second Amendment. And that established that the Second Amendment protects the right to be armed, to go armed outside your home. So that was different than the Heller case. The really impactful part of that decision, though, was that the Supreme Court looked back at what had been happening in the inferior courts, in the federal district courts and the federal circuit courts of appeals since the Heller case 2008. And they saw that the courts had basically ignored what the Supreme Court did in Heller. And what they did in Heller was they analyzed the text of the Second Amendment, what all the words in the Second Amendment mean, what the history of them was, their adoption and so on, and going back to Old English law and so on. And they said, this is what this means. And now, what would be an infringement on that?
Yeah.
And they looked back and they said, well, we looked at the history, the historical tradition of laws and regulations on this right, and there really weren't any. And therefore, these laws that were being challenged at the time had no basis.
Yeah.
Had no basis. That the founders would have felt that they were infringements on this right. Anyway, the inferior courts ignored all this for 14 years until 2022. And in the Bruin case, the Supreme Court told the inferior courts, you must decide, henceforth, you must decide Second Amendment cases on this basis. If the regulations that's being challenged touches on the conduct that is protected by the Second Amendment, to keep and bear arms at its simplest, but also ancillary things like being able to obtain ammunition, being able to obtain a firearm or an arm, and so on, that if the regulation touches on those, it's presumed to be unconstitutional.
Yeah.
Now, when I read that the first day, this is great. It's presumed to be unconstitutional, and then the burden shifts to the government to show that it's not. Mm-hmm. And then they said the only way that the government may show that it's not is by showing that there's a historical tradition of regulation that goes back to the founding, back to the period when the Bill of Rights was established, which was 1791, that there was the same or a sufficiently analogous law that was commonplace at that time. Then maybe the modern regulation could withstand scrutiny and be constitutional. But as we know, there really weren't any such laws. There wasn't a law that said you can't wear your sword or carry your musket this place or that place, or you can't have this kind of firearm, or you can't have this kind of dagger. They didn't have laws like that at the time. They said, don't assault your neighbor, don't rob somebody, don't kill somebody,
don't steal horses.
Common sense laws.
Yeah.
So they told the inferior courts, you have to use this methodology, the same methodology that we used clear back in 2008. And what the inferior courts have been doing is using what was called intermediate scrutiny, although oftentimes it wasn't even that strict. And they said, well, you've got your individual right here. Get on camera here. You've got your individual right here. And you've got the interests of the state here, or it's for the children, or it's for the good of all, or whatever. And we will balance those. And guess what? Always it's for the children, balanced out your individual rights, and they went away. And they upheld every single case that came, every single law that came before them. Usually when there's a big decision like this Bruin decision, it takes years, if not decades, for the jurisprudence to settle itself out as cases go through the courts.
Yeah.
And this case, immediately, really strong pro-Second Amendment, pro-liberty decisions started popping up in federal district and even circuit courts. I say it's like mushrooms after a spring rain. And as you said in the opening, we can't keep up with it. It's very difficult. There was another case today in Illinois. There was one on Friday in the Fifth Circuit. And they're not very good for us.
Wait. Now, hold on. Before you jet into the new stuff, I mean, you've made it up through Bruin. Can you touch on Rahimi real quick? I talked to a lot of people, either they don't know about Rahimi or they don't understand its significance.
Yeah. So the courts said you have to use this methodology going forward with Second Amendment cases. That was in 22. About 2 years later, well, less than 2 years later, there was a case out of Texas with a gentleman named Rahimi, who was fairly apparently a bad dude. He was under a domestic violence restraining order, and he was forbidden from having a firearm. But he did have a firearm. And he had agreed in court to the imposition of this restraining order. He admitted that he had smashed his girlfriend's head against the car dash, I think, and that he had shot at a witness. As it happens, he had also had about 4 other shooting incidents around this time. And so here we had a bad dude, but he wanted relief under, well, there's no historical tradition of disarming people like me. I think that was essentially it. So it went up through the court system and eventually got to the Supreme Court. Well, it was rushed to the Supreme Court by our former Attorney General and not lamented Attorney General Merrick Garland, who rushed this to the Supreme Court. And I think you know why, but maybe our viewers don't. It was because they thought this was such a bad dude, a bad case. Bad facts make bad law, bad court decisions. They thought that if we rush this to the Supreme Court won't dare uphold the principles of their Bruin decision, and therefore they'll begin to limit it, and we'll be able to continue to pass gun control laws, or the Supreme Court will uphold its the logic of its Bruin decision, and they'll give this guy relief, and we will start up the outrage machine, and we'll win the election. This because this was in 24. We'll win the election, and then we'll be able to pack the court and solve this problem. So the court threw him a curveball and said, we're not going to grant Mr. Rahimi, this bad guy, relief. But they went on to describe, well, he was adjudicated as a dangerous person. And it's okay to temporarily, which might be 5 years, might be 10 years, might be 20 years. We don't know what temporarily means, but it's okay for the state to temporarily deprive someone of their Second Amendment rights if they've been adjudicated to be a danger, to be a dangerous person.
Only if.
Yes. And so the full parameters of that haven't been sorted out, but whereas some people thought, well, this isn't good, Rahimi should have got off. We need to, protect the Second Amendment. We need to let this guy go. No, this is actually, I think, pretty good for us, and that's the way it's working out. So subsequently, we have all kinds of decisions that are in favor of people who have been convicted of nonviolent felonies and have been prohibited from a lifetime prohibition on having guns. These are generally as applied cases. They're not a facial challenge. A facial challenge, if successful, would say this law is unconstitutional and it can never, under any circumstances or any set of facts, be constitutional. But an as applied challenge says, as applied to this plaintiff, it was an unconstitutional deprivation of his rights. So there have been a lot of these cases now, and I think we're going to see before too long that the court will say they're going to have to revise this. Right now, any felony or even a misdemeanor under state law that has a sentence of more than 2 years qualifies as a felony under federal law to deprive you of firearms rights for the rest of your life. And I think the court will come in and limit that before long.
So we're caught up now. Mostly caught up. So what's been happening now? Do you want to touch on this thing that came out of Hawaii, or you want to mess with that at all?
Well, there have been several things in Hawaii. Which one are you referring to?
Well, I thought that I read just Friday that basically the court said we're not going to grant anybody a permit, and we don't believe that any of you people have any basis to carry.
Okay, I haven't seen that one. I'll be honest with you. It's hard to catch up.
Okay, all right. Well, let's go ahead.
I don't think that's going to stand. I'm not even sure that the Ninth Circuit will uphold that. Hawaii is in the Ninth Circuit out on the West Coast, and they have a long history of really bad decisions on Second Amendment. And they screw around with, if you get a good decision out of district court, and there have been a bunch of good ones out of district courts on the mainland. If you get a good one, they screw around and send it to a panel, and then if they get a good result for the Second Amendment, they take it en banc, which is a whole bunch of judges, maybe 30 of them.
Well, I didn't take a deep dive into it. I just read it as
there was another one on Friday that had to do with the Fifth Circuit down in Texas, Louisiana area, saying that the federal law since 1968 that bans FFLs, federal firearms licensees, from transferring a handgun to a person. They said that the law prevents them from transferring handguns to somebody under 21. And what the court said was that for the purposes of people who are 18, 19, or 20, so they're young adults, but under the age of 21, that's an unconstitutional deprivation of rights. And that's at the Circuit Court of Appeals level. If you want to talk about this is relevant to Iowa, because we're going to try to change our law in that regard. The Third, the Fifth, and the Eighth Circuit Court of Appeals, and Iowa's in the Eighth Circuit with Minnesota and Missouri, have all ruled in different cases that 18 to 20-year-olds have full Second Amendment rights, and they cannot be deprived of them as a category. You could deprive an individual based on their actions, but not, you just can't say 18, 19, 20-year-olds are not deserving of full Second Amendment rights. They don't have those now, including in Iowa, because the federal law says, even though it's now one court says it's illegitimate, the federal law says a dealer can't sell a handgun to a person under 21, 18, 19, or 20. And Iowa law is really a little odd if we want to get into that. It says you can't, nobody will make available to a person under 21 a pistol revolver except with limited circumstances. And that means that 18, 19, and 20-year-olds can't get a permit to carry, can't get a permit to acquire a handgun, and so on, and even privately, which is allowed under federal law.
As Iowans in Iowa. But if
Ah,
my cousin from Wyoming comes up here who's 19, he or she can't they?
that's right. Since July 1st of 2000, excuse me, January 1st of 2011, when shall issue went into effect, Iowa has recognized all permits from other states. And that includes permits that are issued to people 18, 19, and 20. And other states do issue permits to people between the ages of 18 and 21. So those people have been able to come here all along and carry. In fact, there's really, if somebody, I don't really want to get into this too deeply, but if a person who's 18, 19, or 20 who's here in Iowa, never left the state, they have a handgun. We don't know how they got it. There's really nothing to charge them with if they're carrying this handgun, because the only charge is against the person who made it available to them. And so that's a little bit screwy. So we're going to fix that. We're going to move everything down to the age of 18 and give these young adults their full rights, recognize their full rights. And I think it'll go this year. We've talked to legislators over the last 3 years about this, but we haven't pushed a bill on it. We are stronger this year, and I've talked to leaders of the Democrat Party who generally are loath to join on to anything that we're for, but we have recently had a couple of small bills that we got bipartisan support. I think this is a big one that we may be able to get some bipartisan support from or on, and I hope that's the case.
Yeah. All right. So what other court decisions have we seen come down recently?
Well, there's those 3 circuit courts and some district courts that have said 18 to 20-year-olds have full rights. There was some of those have to do with carrying a gun, some have to do with purchasing a gun. We talked about there have been some convictions overturned for nonviolent felons, including for marijuana users, and that's another thing. On I believe it was Friday, the 8th Circuit that we're in, a 3-judge panel voted 3-0 to overturn the conviction in Iowa of an Iowan who was convicted of having a firearm while in possession, I believe, of marijuana. He was an admitted user of marijuana, and he was convicted. And it went up to the Circuit Court of Appeals, and they said 3-0. That's unconstitutional as applied to this gentleman. His name was Connor, I believe. Yeah, and the reason being that he had not been found to be dangerous. So the court goes, I've only read through the decision once briefly, but the court did go back to the period of 1791 to look and see if there was a historical tradition of laws that were similar to the law that he was convicted under. And they found there was not. They said, well, we did at that time confine certain people who are mentally ill. If they were believed to be dangerous, we confined them. And because we confined them, their rights were restricted. But we didn't confine everybody that had mental illness, just the people that were dangerous. And then there was something that's come up in some other of these cases, a discussion of what was called surety bonds back at that time, at the time of the founding. And surety bonds, in the particular case having to do with firearms, had to do with if a person is riding in terror of the countryside, I think is what it is called in some of these laws. In other words, he's terrorizing his neighborhood, or a particular neighbor is concerned that he's got a grudge, he's going to come over and threaten you with a firearm or a sword or whatever, then you could go to the officials and say, I want this man to have to post a surety bond. Otherwise, his arms should be taken away from him and so on. So he could post a surety bond and continue to be armed, but if he assaulted or attacked anybody, then he'd lose his bond and maybe suffer other consequences. So the court said, well, this isn't similar either, and it only has to do with dangerous people. The defendant in this case has never been shown to be dangerous, has no record of, he had a good record. And then they went on, I think, to talking about some elderly grandmother who's using marijuana for medicinal purposes in her home. Are we going to deny her Second Amendment rights? No. So, or other rights, are you going to deny them freedom of speech, freedom of press, freedom of association, the right of to be secure in home, their person and their belongings.
Yeah.
So that just happened. Then there was a case. I can't remember if it was a circuit court case or it was down in the Fifth Circuit. I don't remember if it was a district court case or a circuit court case early on after Bruin that said the disqualifier on Form 4473. Did you ever see a Form 4473, Michael, in your business?
I may have seen one or two. Yeah.
Okay. I imagine a lot of our viewers know about this form. You have to fill it out when you go to a dealer to buy a gun. And it has a bunch of questions. And you better answer yes to one and no to all the rest of them. Well, one of them is, are you under indictment? Are you under indictment? It used to be for a federal crime. And now it's just, are you under indictment?
Yep.
And the court ruled that that's unconstitutional because indictment is not conviction.
Oh, I never thought about that. If they, does that mean that ATF will be changing that form very quickly, or what are you supposed the ramifications?
Well, they haven't yet. That was about 2 years ago.
Yeah.
And then last week there was also a case where I think it was the Fifth Circuit. No, it was a district judge in Mississippi. A district judge in Mississippi, very grudgingly, I'll admit, said that the ban on possessing unregistered machine guns was unconstitutional under the Second Amendment. There's another case. I was just reading the Stephen Holbrook article. There's another case coming up through the courts on that in the Fourth Circuit, I believe. And so they're very unlikely to say, yeah, go out and buy machine guns. It's fine. So there'll be a circuit split between the Fifth Circuit and the Fourth Circuit, and this will probably go to the Supreme Court. I'm not, frankly, that anxious to see that happen because I'm not sure the Supreme Court is ready to, on its own, undo the National Firearms Act of 1934. But we'll see. I think it'd be better off if Congress started to undo that on its own, and in light of some of these opinions and a new understanding, which is actually the old understanding, the original understanding of the Second Amendment, what it means.
I'd like to see him do that too. We've talked about this before. We have not very many, thank goodness, but there are items in Iowa's code that are clearly, in light of Bruin and some of these other decisions, are way out there. I mean, there should be some things that we purge from code that shouldn't be there anymore. So it's going to take the federal government a little time to keep up or catch up. And I'm like you, I would really rather have legislators legislate than courts having to correct all this. So I think it's a matter of how it should be done. But you know how you've heard me say this before, Richard. I don't care about the labor pains. Just give me the baby. So I guess we'll see.
Yeah, I wish it was that. Well, I don't want to insult women by saying that's easy, but I wish we could just, have the stork deliver it to you, buddy. But it's hard work, let me tell you.
Oh, also touch on what happened the other day with our neighbors over here in Illinois. You remember that one?
Okay. Did I not mention it? Yes. Over in Illinois, they have some lovely legislation called the Firearms Owner Identification Act, and you have to have an ID card to own or purchase firearms or ammunition. If you move to Illinois with a whole bunch of guns, half of them have been made illegal by Illinois law recently anyway, and that's being contested in the courts. But just any old thing, an old 16 gauge single shot shotgun like my granddad gave me when I was a kid. It was an old gun then. You're going to have to tell the state about it and get approval from the state police to that you have this firearm owner's identification card. And I believe this was a case involving a woman, and I haven't read the details on it yet, but the state court in Illinois said, no, this is unconstitutional. Again, going back, there's no historical tradition of making people jump through hoops to possess a firearm, especially in their home. And I believe this was a matter of in their home. And that's what the FOID, F-O-I-D, Firearms Owner Identification Card, does. It's wrong. It's been wrong. We've all known it's been wrong for a long time. And now the state court has ruled that way. And we'll see where that goes. But there's just so much that the Bruin case, which really establishes that the courts have to use the Heller methodology from 2008, has really overturned Second Amendment jurisprudence.
Oh, yes. It's
and
basically
people are resisting it. Some of the courts are resisting it, but it's going that way.
It's been kind of interesting because when I listen to my pastors, or I pay close attention to what people like you or John Reed or my dad, as mentors would talk about, the context matters supremely. And the court said in Bruin, essentially, we want to look at the original context of what the Second Amendment means. And we want to apply that universally, because we don't have any business saying, well, it's a different time. Or we don't have any business saying, well, this is a living, breathing document. We don't have any business playing those shenanigans. So I think it's very important. Now, before we move forward, I think we're about out of time. But just so for the context of the FOID card in Illinois, I don't think very many people actually understand what that is. You've got to go apply for a special card so that you can actually get in line to go buy something. But here's what most people don't understand about that. I had he became a friend. He started as a customer that was on the Iowa State trap team or something like that. And he was shooting, obviously, shotguns and long guns, whatever else. And he came over here to pick something up or have me make a modification when he was 20, I think it was. And he told me at his first availability as an 18-year-old, he applied for that card in Illinois. And as a 20-year-old, and the reason that this was significant, he was 1 week, Richard, from turning 21. He had not yet been issued his card.
Right.
He had waited almost just a few days, just a few weeks short of 3 years to be issued his card, and they were that far behind. So it isn't just like, well, what's the big deal with going and getting a card? You get a driver's license. No, one is a right. The other one is some level of privilege. But what we're talking about here is the system was deliberately rigged or strewn out so that they would never actually make good on it. Now, can you imagine waiting 3 years for a little card so that you could go buy a gun? That's absolutely preposterous.
They make you renew that periodically, and they're way back. They're still way backlogged. I think it's better than that now, but they're way backlogged. And so what happens when your card runs out? You still got guns in your house. You're not allowed to do that. Something you said earlier before we go, reminded me about the Bruin case. Another important thing there was Justice Clarence Thomas had said in several dissents to other cases previously that Second Amendment rights are not second-class rights, which of course is very true. They're very fundamental rights. But in the Bruin decision, he had a great line that we referred to the Second Amendment's unqualified command, and that is shall not be infringed. It's an unqualified command, and that's why if the conduct that you want to participate in is covered by the plain text of the Second Amendment, and all those words have been defined by the Supreme Court, so we don't need to revisit that, then the law is presumed to be unconstitutional, and the burden shifts to the government, and they have to prove it. And that's why everything is in upheaval now. And we're in pretty good shape here in Iowa, but there are some things we need to do, and it's frankly legislative malpractice if the legislature doesn't clean it up now. For instance, on this 18, 19, and 20-year-old, we don't want our attorney general to have to go to court when somebody sues and try to defend the indefensible.
Yep, agreed. Anything else before we go?
No, maybe we'll have another one later about bills. We don't have a lot of bill numbers yet, but we have a lot of stuff that's going to be moving in the legislature, and we're feeling pretty good about a lot of important stuff. We're not going to get everything we'd like, but we're going to get some of the really important stuff, I think, this year.
I'm feeling pretty good about it too, but you never know. So we got to keep up the engagement. We need to keep up, the touches. So when we have things like the Second Amendment Day, which is coming up, we need people to come out and do that. And also for people watching out there, I understand. I truly do. Richard, I know you know this, that it's February when we do this. And this year we're going to be doing it on February 18th on a Tuesday. Well, we can get really cold weather. We can have, some snow hit the ground, maybe worse. But what we've been doing to help people with that is driving a shuttle bus from, I believe it's parking lot 16. You'll have to go to Iowa FC under the events tab and get the full information. But there's a designated parking lot, and we're running a shuttle bus. So all you got to do is go to the parking lot, flash your lights, honk at us. I'm driving it. I'll see you. And I'll get you back and forth from your warm car to the front door of the Capitol building and back. You're not going to have to trudge through the snow. You're not going to slip and fall. We'll help you in and out. So there's no reason not to come if you're worried about things like that. And we have given a lot of rides to to a lot of people over the years that were really appreciative. So take us up on that. Come out there, spend the day, listen to the speakers. Jeff Strecker is going to be there. You've seen him from Black Hawk Down. Fort Dodge kid made good. Very influential man. We're glad to have him. A lot of folks from NRA are going to come in town and help us out. It's going to be fantastic. So we want people to come. If my 15-year-old daughter can show you how to put in a card to talk to your House rep or your senator, you can too. You've got no excuse not to come out and say, hey, I'm here today with IFC and I want to talk with you about these bills. So we'll see everybody then. We need to keep that level of engagement up so we get these bills.
One point, Michael, do you think any of our viewers ever carry a gun? I think some of them might. So when you come to the Capitol for the last 8 years, you've been able to carry a concealed pistol or revolver, concealed handgun on your person. Just tell the guards when you come through that you're lawfully armed, and they may ask you where it is on your body because the magnetron will beep when you walk through it. But that's perfectly legal, and they will allow knives in there as long as the blade's not over 3 inches. So I just want you to know that. It's not a requirement to go up there, be armed, but you may, and you can thank IFC for that.
Yeah, it's the safest place in America, no doubt about it. All right, thank you. Richard, I appreciate your time tonight. We'll see you soon.
You bet, Michael. Take care.